Section 17. Jurisprudence. Number 1. Law. Footnote. Civil law. End footnote. Law, as we understand the term, with all its paradoxes and refinements, is utterly unknown to the Chinese, and it was absolutely necessary to invent an equivalent for the word barrister, simply because no such expression was to be found ready-made in the language. Further, it would be quite impossible to persuade even the most enlightened native that the bar is an honorable profession, and that its members are men of the highest principles and integrity. They cannot get it out of their heads that Western lawyers must belong to the same category as a certain disreputable class among themselves, to be met with in every Chinese town of importance, and generally residing in the vicinity of a magistrate's or judge's yamen. These fellows are always ready to undertake for a small remuneration the conduct of cases, insofar as they are able to do this by the preparation of skilfully worded petitions or counter-petitions, and by otherwise giving their advice. Of course they do not appear in court, for their very existence is forbidden, but their services are largely availed of by the people, especially the poor and ignorant. At the trial, prosecutor and accused must each manage his own case, the magistrate himself doing all the cross-examination. We say prosecutor and accused advisedly, for as a matter of fact civil cases are rare in China, such questions as arise in the way of trade being almost invariably referred to some leading guild, whose arbitration is accepted without appeal. Now, we know of no such book as Laws of Evidence in the whole range of Chinese literature, yet we firmly believe that the intellects which adorn our own bench are not more keen in discriminating truth from falsehood and detecting at a glance the corrupt witness than the semi-civilized native functionary, that is, when no silver influences have been brought to bear upon his judgment. The Chinese have a penal code which, allowing for the difference in national customs and habits of thought, stands almost unrivalled, and with this solitary work their legal literature begins and ends. It is regarded by the people as an inspired book, although few know much beyond the title, and seems to answer its purpose well. But inasmuch as in China, as elsewhere, summum jus is not unfrequently summa injuria, a clever magistrate never hesitates to set aside law or custom, and deal out Solomonic justice with an unsparing hand, provided always he can show that his course is one which reason infallibly dictates. Such an officer wins golden opinions from the people, and his departure from the neighbourhood is usually signalized by the presentation of the much coveted testimonial umbrella. In the reign of the last emperor but one, less than 20 years ago, there was an official of this stamp employed as second prefect in the department of Hanyang. Many and wonderful are the stories told of his unerring acumen, and his memory is still fondly cherished by all who knew him in his days of power. We will quote one from among numerous traditions of his genius which have survived to the present day. A poor man, passing through one of the back thoroughfares of Hankow, came upon a taels 50 note, (footnote, 50 taels equal to about £15), end footnote, lying in the road and payable to bearer. His first impulse was to cash it, but reflecting that the sum was large, and that the loser might be driven in despair to commit suicide, the consequences of which might be that he himself would perhaps get into trouble, he determined to wait on the spot for the owner, and rest content with the thanks money he was entitled by Chinese custom to claim as a right. Very shortly he saw a stranger approaching, with his eyes bent on the ground, evidently in search of something, whereupon he made up to him and asked him at once if anything was the matter. Explanations followed, and the taels 50 note was restored to its lawful possessor, who, recovering himself instantaneously, asked where the other one was, and went on to say that he had lost 2 notes of the same value, and that on recovery of the other note he would reward the finder as he deserved, but that unless that was also forthcoming he should be too great a loser as it was. His benefactor was protesting strongly against this ungenerous behaviour, when the second prefect happened to come round the corner, who, seeing there was a row, stopped his chair, and inquired there and then into the merits of the case. The result was that he took the taels 50 note and presented it to the honest finder, telling him to go on his way rejoicing, while turning to the ungrateful loser, he sternly bade him to wait until he met someone who had found 2 notes of that value, and from him endeavour to recover his lost property. End of section 17. Section 18. Jurisprudence, number 2. From the previous sketch it may readily be gathered that the state of Chinese law, both civil (that is, local custom) and criminal, is a very important item in the sum of those obstacles which bar so effectually the admission of China, not into the cold and uncongenial atmosphere euphemistically known as the Comity of Nations, but into closer ties of international intercourse and friendship on a free and equal footing. For as long as we have extraterritorial rights and are compelled to avail ourselves thereof, we can regard the Chinese nation only de haut en bas, while, on the other hand, our very presence under such to them abnormal conditions will continue to be neither more nor less than a humiliating eyesore. Till foreigners in China can look with confidence for an equitable administration of justice on the part of the mandarins, we fear that even science, with all its resources, will be powerless to do more than pave the way for that wished for moment when China and the West will shake hands over all the defects sustained by the one and all the insults offered to the other. It is in the happily unfrequent cases of homicide where a native and a foreigner play the principal parts that certain discrepancies between Chinese and Western law, rules of procedure and evidence, besides several other minor points, stand out in the boldest and most irreconcilable relief. To begin with, the penal code and all its modifications of murder, answering in some respects to our distinction between murder and manslaughter, is but little known to the people at large. Nay, the very officials who administer these laws are generally as grossly ignorant of them as it is possible to be, and in every judge's yamen in the empire there are one or two law experts who are always prepared to give chapter and verse at a moment's notice. In fact, to guide the judge in delivering a proper verdict, and one such as must meet with the approbation of his superiors. The people, on the other hand, know but one leading principle in cases of murder: a life for a life. Under extenuating circumstances cases of homicide are compromised frequently enough by money payments, but if the relatives should steadily refuse to forego their revenge, few officials would risk their own position by failing to fix the guilt somewhere. As a rule, it is not difficult to obtain the conviction and capital punishment of any native, or his substitute, who has murdered a foreigner, and we might succeed equally well in many instances of justifiable homicide or manslaughter. It is when the case is reversed that we call down upon our devoted heads all the indignation of the Celestial Empire. Of course any European who could be proved to have murdered a native would be hanged for it, but he may kill him in self-defence or by accident, in both of which instances the Chinese would clamour for the extreme penalty of the law. Further, hearsay is evidence in a Chinese court of justice, and if several witnesses appeared who could say that some one else told them that accused had committed the murder, it would go just as far to strangling or beheading him as if they had said they saw the deed themselves. The accused is, moreover, not only allowed to criminate himself, but no case being complete without a full confession on the part of the guilty man, torture might be brought into play to extort from him the necessary acknowledgment. It is plain, therefore, that Chinese officials, prosecuting on behalf of their injured countrymen, are quite at sea in an English court, and their case often falling through for want of proper evidence, they return home cursing the injustice done them by the hated barbarians, and longing for the day which will dawn upon their extermination from the flowery land. On the other hand, the examination of Chinese witnesses, either in a civil or criminal case, is one of the most trying tests to which the forbearance of foreign officials is exposed in all the length and breadth of their intercourse with the slippery denizens of the Middle Kingdom. Leaving out of the question the extreme difficulty of the language, now gradually yielding to methodical and persevering study, the peculiar bent of the Chinese mind, with all its prejudices and superstitions, is quite as much an obstacle in the way of eliciting truth as any offered by the fantastic, but still amenable, varieties of Chinese syntax. We believe that native officials have the power, though it does not always harmonize with their interest to exercise it, of arriving at as just and equitable decisions in the majority of cases brought before them as any English magistrate who knows Taylor's law of evidence from beginning to end. They accomplish this by a knowledge of character, unparalleled perhaps in any country on the globe, which enables them to distinguish readily, and without such constant recourse to torture as is generally supposed, between the false and honest witness. The study of mankind in China is, beyond all doubt, man and his motives for action on every possible occasion and under every possible condition. Thus it is, we may remark, that the Chinese fail to appreciate the efforts made for their good by missionaries and others, because the motives for such a course are utterly beyond the reach of native investigation and thought. They are consequently suspicious of the Greeks, et dona ferentes. The self-denial of missionaries who come out to China to all the hardships of Oriental life, though, as a facetious writer in the Shanghai Courier lately remarked, they live in the best houses and seem to lead as jolly lives as anybody else out here, to say nothing of gratuitous medical advice and the free distribution of all kinds of medicine, all this is entirely incomprehensible to the narrow mind of the calculating native. Their observations have been confined to the characters and habits of thought which distinguish their fellow countrymen, and with the result above mentioned. Of the European mind they know absolutely nothing. As regards the evidence of Chinese taken in a foreign court of justice, the first difficulty consists generally in swearing the witnesses. Old books on China, which told great lies without much danger of conviction, mention cock killing and saucer breaking as among the most binding forms of Chinese oaths. The common formula, however, which we consider should be adopted in preference to any hybrid expression invented for the occasion, is an invocation to heaven and earth to listen to the statements about to be made, and to punish the witness for any deviation from the truth. This is sensible enough, and is moreover not without weight among a superstitious people like the Chinese. The witness then expects the magistrate to ask him the name of his native district, his own name, his age, the age of his father and mother, if alive, the maiden name of his wife, her age, the number and ages of his children, and many more questions of similar relevancy and importance, before a single effort is made towards eliciting any one fact bearing upon the subject under investigation. With a stereotyped people like the Chinese, it does not do to ignore these trifles of form and custom. On the contrary, the witness should rather be allowed to wander at will through such useless details, until he has collected his scattered thoughts, and may be safely coaxed on to divulge something which partakes more of the nature of evidence. Under proper treatment, a Chinese witness is by no means doggedly stubborn or dotishly stupid. He may be either or both, if he has previously been tampered with by native officials, but even then it is not absolutely impossible to defeat his dishonesty. Occasionally a question will be put by a foreigner to an unsophisticated Boer, never dreamt of in the philosophy of the latter, and such as would never have fallen from the lips of one of his own officials. The answers given under such circumstances are usually unique of their kind. We know of an instance where a boatman was asked, in reference to a collision case, at what rate he thought the tide was running. The witness hesitated, looked up, down, on either side, and behind him, and finally he replied, "I'm a poor boatman. I only earn 150 cash a day. How can you expect me to know at what rate the tide was running?" End of section 18.